The mobile High Court sitting at Ggaba resumed on day 10 of the trial, expecting to receive testimonies from two other witnesses mentioned by the murder suspect, Okello Onyum. Unfortunately, the two witnesses were inaccessible.
In the circumstances, since the remaining witnesses can't be found, we close the defense case.
Given the situation, Justice Alice Komuhanji Hauha asked the defense and the prosecution teams to proceed with the submissions.
We would ask for 3 hours to do this. We summarize.
The court granted the defense 3 hours to prepare the submissions and resumed later in the afternoon. Okello's lawyers challenged that the prosecution had overlooked the need to establish the mental status of the accused. Richard Kumbuga, a defense lawyer, argued that the court was trying a mentally unstable person.
In case this court finds him guilty, is to find an innocent guilty of an innocent person, dangerous to the legal profession, and worry to the families in Uganda plus elsewhere that have people with such challenges.
Kumbuga challenged that since a matter of Okello's mental state had arisen, the prosecution should have interested itself in establishing the fact.
Once evidence of unsoundness of mind arises, is detrimental to the prosecution case. No cogent psychiatric evidence was tendered to negate the mental illness of the accused before you throughout the prosecution evidence.
He pointed out that a witness had testified in court to having the information that Okello was at Butabika Mental Hospital for 8 to 9 months.
Or his big brother, DW2, came to court and said he was ever in a mental facility, that's Butabika Hospital.
Okello's behavior in court formed part of the defense as they related it to delusions, hallucinations, and abnormal posturing.
This particular accused person has been laughing frequently.
Okello's lawyers argued that a psychiatrist had pointed out in the course of the trial that it was possible to behave normally during psychotic episodes, that the accused was distressed around the period, and testified to killing his own brother. The defense also stated that it was not illegal for the accused to conduct web searches on the internet. Revelation was made in the course of the trial that Okello had searched on the internet about ISIS beheadings. In response, the prosecution argued that the burden of proving that the accused was mentally unstable had shifted to the defense the moment they brought it up.
There is a legal presumption that every living being is sane. And whoever wants to dispute that presumption of sanity, my Lord, bears the burden to prove the contrary. And therefore, my Lord, it is not right that the defense faults prosecution for failing to lead evidence of his insanity. I beg your pardon, my Lord.
The prosecution pointed out that the defense was attempting to run away from the ingredients showing that the accused acted with malice aforethought. They also stated that the defense did not dispute one of the ingredients of the case, which is murder, that it had occurred.
We want to add, my Lord, that throughout his defense, the accused never denied causing the death of the deceased children. He only claimed that he believed he did not have the intention to cause their death.
The prosecution told the court that they had proven the ingredients of murder.
The biological parents of the deceased children that testified to the effect that these infants died and were buried.
They highlighted that it was not in dispute that the homicide was not accidental or legally authorized. They argued, proving through the testimonies, that the heinous murders were committed with malice aforethought. They pointed at this, premised on the deadly weapon used, the nature of the injuries, and the attempt to conceal the evidence when the accused threw the knife outside the fence.
Evidence found the DNA of the accused on the knife handle, which was Exhibit 4.
Another ingredient is participation, which the prosecution told the court that it was proven when it was found that Okello was directly involved.
My Lord, that evidence and more that we laid on record is sufficient to place the accused at the scene, but also prove his direct participation.
Meanwhile, the court assessors have advised the court to convict the murder suspect, Christopher Okello Onyum.
Putting the accused person at the scene of crime by virtue of the DNA examinations made on his sunglasses. With the above, we are convinced that the prosecution has also proved the fourth ingredient beyond reasonable doubt.
The court is scheduled to issue the judgment on Thursday this week. Jackson Onyango, NTV.